Welcome and thank you for joining us. Today's webinar is presented by the Ministry of Finance, the Canadian Bar Association, and the BC Land Title and Survey Authority. Now, I'd like to begin with an acknowledgement that we meet on the traditional and unceded territories of the Coast Salish peoples, and we thank them for their hospitality. We make this acknowledgement to invite you to explore the rich history and knowledge of Indigenous peoples and continue to learn more about their experience in Canada. We acknowledge the significant harm done to Indigenous peoples, families, communities, and individuals as a result of the role the legal system and the legal profession itself has played. Now, my name is Parissa Hurst, and I'm a real estate lawyer with the law firm of Borden Ladner Gervais. I'm also an executive with the BC CBA Real Property subsection, as well as the LOTA subcommittee. Joining me today, we have Ruben Danacote, who's the Director and Administrator of the Landowner Transparency Registry for the Land Title and Survey Authority of British Columbia, as well as Tiffany Norman, who's the Director of Real Estate Policy with the Ministry of Finance and was involved in the drafting of Landowner Transparency Act, as well as being responsible for the Real Estate Services Act and the Real Estate Development Marketing Act. Now, I've come to know Tiffany and Ruben as a result of collaborating with them on the creation of this presentation, so you'll hear a bit of a conversational back and forth between us. So today's content has been curated from numerous conversations within the legal profession, as well as common questions and errors that Tiffany and Ruben and their respective offices have come across. So for the purposes of today's session, we'll start off with hearing from Ruben in terms of a bit of an update and a reminder on filing matters. Following his presentations, we are going to then go into a guided conversation to review 5 complicated ownership structure and discuss how LOTA applies to those structures. Now, I encourage you to watch the very end here because as we go through, the complexity of the structures get more complicated, and there's valuable commentary by both Tiffany and Ruben that will be provided. Now, just a few more housekeeping matters to take note of. This session is recorded, and a link to the recording will be posted on the Land Transparency website. As well, the presentation material is posted on the website as well and updated to reflect the most current version. So, without further delay, over to you, Ruben, to give us a bit of an update on administrative and filing matters.
Thank you, Parissa. Before I get into the specifics of the administrator's filing requirements, I'd just like to take a moment to extend my sincere thanks on behalf of the Land Title and Survey Authority of British Columbia. A big thank you to the Real Property Subcommittee of the Canadian Bar Association BC Chapter. There are many organizations, as you can see here, who have contributed to material, content, facts, around specific scenarios that we'll be talking about in the preceding presentation. And so thank you to Borden Ladner Gervais, Boughton Law Corporation, Dentons Canada, Clark Wilson, Lawson Lundell, Sincerity Law Group, Stewart Title Guarantee Company, and especially a big thank you to Tiffany Norman from the Ministry of Finance, and to Parissa Hurst and Matthew Boucher, who have worked with us as a group collectively, together with some of my other colleagues who are not actually present here, but in the background, who have contributed significantly to presenting this material to you today. So thank you all very much. And then prior to getting into the administrative requirements, of course, we want to state some disclaimers and limitations. First of all of the content and discussions here do not constitute legal advice, nor are they a substitute for law. There are also, all of the material is based on today's interpretation of the legislation, the Government of BC's interpretation of the different scenarios, and may be subject to changes to the legislation or subsequent changes to the Government of BC's interpretation or court decisions. So on to filings. So we all know that we've got a big date coming up this year on November 30th, 2022, a deadline as required under Sections 15.1 of LOTA for filing by pre-existing registered owners that are reporting bodies. As at end of April, there were a total of about 350,000 transparency records in the registry, and that continues to grow with new filings. Pre-existing filings are still nominal at around 15,000 transparency reports, and then that continues to increase as we file progressively. And as always, please continue to file those progressively and not hold until the latter part of this year. So the following is really a summation of all of the filings that would be required under LOTA. So I'm just going to cover them at a high level and just talk to you about when those filings are required, with particular emphasis on items 2, 6, and 7. So first of all, an application to register an interest in land. So whenever there's an application that is made to register an interest in land, a transparency declaration is required most of the time, and a transparency report if the transferee is a reporting body. So this is the only time that a transparency declaration is required. In the case of item 2, where we're filing for a pre-existing registered owner of an interest in land, it is only a transparency report that's required by November 30th this year. So in the case of a transparency report by pre-existing, you do not require a transparency declaration at all. The third item, interest in land that is held by a reporting body. Now, if that interest in land transfers to another owner, so it sells, for example, before the end of this year, then there is no reporting required whatsoever by the previous reporting body. And that's because the first part takes care of that requirement, where the new transferee is now filing a transparency declaration and or a transparency report. Now, in item 4, if a pre-existing owner that is a reporting body but has not filed a transparency report, but ceases to be a reporting body before the end of this year, November, then no report is required. So for example, a pre-existing owner that is a trustee has ceased to be a trustee before this end of this year, then no transparency report is required. So this is on the assumption that the reporting body has not filed a transparency report. Item 5, so this is when a requirement under sections 15 sub 4 and 5, where a reporting body becomes, so a registered owner becomes a reporting body. So a pre-existing registered owner is just an individual who legally owns that legal interest and the beneficial interest, then becomes a reporting body, for example, becomes a trustee. Then within 2 months of becoming a reporting body, the trustee, in this case, will have to file a transparency report. Emphasis on item 6, on a change of interest holders. Whenever there's a change of information about an interest holder, the reporting body has an obligation within 2 months of becoming aware of that change to file a transparency report. So this is different than, and I'll cover this in a subsequent slide. This is very different than filing an application under section 42 on change of interest, or on change for a correction or a change of information. That is only reserved for applications by actual individuals who are interest holders. So this is for reporting bodies to file a new transparency report under section 16. Item 7, whenever there's actually a requirement by the reporting body to correct or complete information in a previously filed transparency report. For example, if the transparency report contained incorrect information about the an interest holder's SIN number, or there was a spelling error in an interest holder's name, that provision under Section 17 is always available for the reporting body to file a brand new transparency report to correct or complete that information. And finally, item 8, whenever a registered owner who has already filed a transparency report has ceased to be a reporting body, so a trustee is no longer a trustee, or if a reporting body has now become an excluded relevant corporation or an excluded relevant trust, then the requirement under Section 17 is to file a notice to the administrator, and that is within 2 months of ceasing to be a reporting body. So they're having operated the registry for well over a year now. There's some common observations of confusion, some mistakes that we've observed from legal professionals, and this is really intended to help you as a bit of a guide for do's and don'ts. So there's some top 6 of items that we've consistently observed. The first is there's a lot of questions around when an application is made to file a land title application, questions around is a transparency declaration required or not. And of course, if it's a corresponding interest in land as defined in Section 1 of LOTA, then LOTA can and will likely apply. There is a very quick reference in landtransparency.ca, there's a link here provided, that will actually provide you with a very quick summary of the nature of interest that actually do require a transparency declaration. Caution, please do not declare an exclusion from LOTA unless the interest in land is either not an interest in land as defined in LOTA, or if the land is excluded under Section 6. Once you declare that exclusion, there is no way to reverse that unless we do it manually for you. Second, filing of a transparency report by a pre-existing owner by this year. Please do not prepare a transparency declaration with the report. We've seen a lot of those. If you have prepared a transparency declaration and a transparency report in the past, it's quite likely just sitting in your dashboard. It hasn't been submitted into the registry. So please do look into that. And if you've done that, the only way to correct that is to completely delete that transparency deck and the transparency report and file a brand new transparency report. Again, it has to be done by November 30th, 2022. If there are multiple pre-existing registered owners of an interest in land and both are reporting bodies, each reporting body has to file its own transparency report. Don't attempt to try to include those 2 reporting bodies into one transparency report. It just will not work, and it's not in keeping with the statute. Fourth item, information about interest holders, let's say, has changed since the last transparency report is filed. So as I covered in the previous slide, the transparency report, now a new report is required under Section 15 within 2 months of becoming aware of the change. So this is when there's a change of interest holders. Please do not file an application under Section 42 to change or correct information. That is only available for interest holders and or settlers who are individuals. Also, please do not call or email with that request, because that provision to file a new transparency report is available and must be filed under Section 16, my apologies. If there is incorrect information about an interest holder's, let's say, spelling of last name, or if you had the SIN number previously in the last report entered into the report incorrectly, then you want to correct that information. You certainly can. You have that provision under Section 17 to correct or complete information that was previously filed in a transparency report. Again, here you're filing a complete transparency report, not just partial information about that change. Reminder, do not file a Section 42 application to change or correct, and please do not email or call requesting that change. There is a provision, Section 17. And lastly, what I want to just point to is, in the case of a transparency report where there may be individuals who are minors under the age of 19. We've heard a lot of concern from yourself and clients that about the disclosure of information about minors. So under LOTA, the administrator is required to omit all primary identification information in relation to individuals who are under the age of 19. So really the ask is either inform the interest holder and or the guardian of the individual that the primary identification information will only be publicly accessible when they become 19. You don't even have to file an application to omit under Section 40 because it's a mandatory omission of information. However, that information will automatically be publicly accessible once the individual becomes 19. That's the time when you may want to consider making an application under Section 40. So just wanted to highlight a couple of key things you might have seen in our recent newsletters. Effective May 1st, 2022, there have been two changes to filing fees. The first is a transparency declaration, which has changed from $5 to $7.50. And the transparency report, which was previously $35, is now $50. There are no changes to any other statutory fees in respect of LOTA. Search fees remain the same and all application fees remain the same as well. You're probably very familiar with this website by now. And so I just wanted to point to the fact that we continue to update land transparency with more information and evolve information as things change. The information here that we're providing to you will continue to be available in landtransparency.ca, including the recorded video as well. And finally, for contact information, in regards to administrator filing requirements, guidance on technical filing, there's videos and resources, including links to other resources such as the Government of BC's website, can all be found at that website address. And if you still can't find any information there or require more guidance, then with respect to filing requirements, applications, and notices, you can certainly email at loader@ltsa.ca, my technical support at LTSA. You've got the contact numbers which you have traditionally used. So that is your point, your go-to point of contact for guidance on administrators filing requirements. And Parissa, just handing it back to you now.
Thank you, Ruben. So let's jump right into it. We're going to look through and discuss 5 complicated ownership structures and discuss with Tiffany and Ruben how LOTA applies to each structure. I do encourage you to stay to the very end here because it'll get more complicated and I'll ask the tough questions from both Ruben and Tiffany. So jumping into our first slide. Now, just a note that this slide was updated on May 9th to make it even more complex, and we'll speak to it today. This is a typical structure you may see with a bare trust arrangement where the ownership is bifurcated, with the bare trustee company owning 100% legal ownership of a land for the benefit of a company, in this case, Company A, who has the beneficial interest in the land. Now, for the purposes of this presentation, I will refer to beneficial interest. As you know, beneficial owner is a specific defined term under the Act. So when speaking about bare trustee nominee structures, I'll speak to beneficial interest to keep things separate and clear. In this structure, the bare trustee company is fully owned by a publicly owned entity whose shares are traded on a designated stock exchange. And Company A is owned through Company B all the way up to the public company through these subsidiaries, and ultimately also owned by the public company. Now, we have shown 3 different classes of shares. So we have Class A, B, and C. Class C shares being the publicly traded shares, with Class A and B being held by controlling shareholders. So a couple of complicated questions arise on this structure. First of all, question is whether or not this is a reportable structure, and whether or not the Bear Trustee Company needs to report and file a transparency report, given that it's ultimately owned by a publicly owned entity. Secondly, the question arises, who's the settlor in this structure? Bear trusts are different than some of the other trust ownership structures we may be used to, so it's a useful question to discuss with Tiffany and Ruben. And lastly, in looking at this structure, I want to put to Tiffany whether or not the controlling shareholders get reported on in the transparency report, given that they have a controlling interest of the Class A and B shares. So, Tiffany, over to you.
Thanks, Parissa. So when I start looking at one of these examples, the first question that I always want to look at is what kind of reporting body do we have here? So in this case, Bear Trustee Company is a corporation, and they're also the trustee of a relevant trust. In this example, Bear Trustee Company isn't a relevant corporation because it's wholly owned by an excluded corporation, that publicly traded company. But even if Public Trustee Company were a relevant corporation, we see under Section 13 of the Act that you would treat the reporting body as the trustee of a relevant trust in the case where it's both a relevant corporation and a trustee. So in this case, we're dealing with a reporting body who's the trustee of a relevant trust. So we need to try and identify any beneficial owners under Section 2 of the Act. So the next question is, who is a beneficial owner? Under Section 2 of LOTA, a beneficial owner includes a person who's a corporate interest holder in a relevant corporation that has a beneficial interest in the interest in land. So in this case, Company A has the beneficial interest, so we need to look to see if Company A has any corporate interest holders as defined under LOTA. In this case, though, we see that Company A doesn't have any corporate interest holders, and we can determine that by going through the indirect control provisions in the regulations. So we see that Company A is wholly owned by Company B, and Company B is a company that's excluded under Schedule 1 because it is also wholly owned by a company that's listed on a designated stock exchange. So the indirect control provisions require looking through a chain of relevant intermediaries, but the term relevant intermediary, when it deals with a corporation, is a relevant corporation. So since Company B and Public Company aren't relevant corporations, then they don't count as entities that we need to look through in the chain. So for that reason, we have a break in the train of indirect control, and we don't have to keep drilling through to find individuals. So for that reason, because we don't need to keep drilling through, because we haven't met those control tests, in this case, we don't have any beneficial owners. Even with a controlling shareholder of the public company, we don't need to capture them because they aren't a corporate interest holder, again, because we have these non-relevant corporations as intermediaries. It's important to note, though, that Bear Trustee Company is still a reporting body. So even though there are no beneficial owners, they still need to file a transparency report. But in this case, the report will just set out the fact that there are no beneficial owners as defined under LOTA. So in terms of the questions about settlers, it's always going to depend on the facts of the trust instrument. It's always going to be really important to look at the specific trust arrangement that you're looking at. However, I will note that under LOTA, the definition of settlor doesn't include a settlor who's also a trustee of the relevant trust. So even if the trust instrument said that Bear Trustee Company was the settlor, they wouldn't need to be captured as a settlor on the transparency report because of that definition in the Act. I know that in a lot of cases it's the beneficiary, so in this case Company A, who might be considered the settlor, and in that case you would capture them. And Company A's primary identification information would be included on the transparency report as a settlor. So back to you, Parissa.
Thanks for that, Tiffany. Now, Ruben, I'm sure you've come across a couple of common issues and mistakes with a structure like this, and love to hear from you as well how a transparency report may be completed for a structure like this where ultimately no one's getting reported on.
Sure, Parisa. Few observations. One is has been a bit of a common misconception that because there's an excluded relevant corporations in the chain, that the bearer trustee in this case may not need to file a transparency report. And as Tiffany pointed out, the bearer trustee in this case is not an excluded trust under LOTA. There is no exclusion, notwithstanding the fact that the bearer trustee company is 100% owned by a public corporate company that is excluded. So the bearer trustee company must still file a transparency report, as mentioned by Tiffany. And in this scenario, the assumption here is that there is no settlor of the trust. And so in the subsequent slides, which are provided for reference, you'll see that within the transparency report, there is an option to select no settlors in this case. And finally, because the determination because the chain is broken at company B, which is an excluded relevant corporation, which is a wholly owned subsidiary of public company. So that is an exclusion under Schedule 1, 1T of LOTA. Then there's a requirement under Section 21 to provide a statement. And so if we advance to the subsequent slides, you'll see a sample statement that we've provided as just an example. And that what you see here is the no settlor option. And if we advance to the next and that slide there, you'll see that just as an example, here's a statement that you would typically consider providing. So in this case, the reporting body, which is the bearer trustee, has determined that there are no individuals who are beneficial owners. And in this case, the class of beneficiary is a company that is directly owned by an excluded corporation under under Section 1T of Schedule 1 of LOTA. And so this refers to company B, which is the wholly owned subsidiary of the publicly traded company that under a designated stock exchange. And back to you, Parisa.
Okay, so just to pause there, Ruben, we don't need to append an entire thesis on how the conclusion was arrived at, correct?
That's correct. Section 21 is very specific. In this case, in the case of a trustee, is really to provide a statement in regards to the class of beneficiaries. The reason being why there are no interest holders in this scenario. So no further information is required.
Okay. Well, thank you, Ruben. So moving on to the second example, and as I mentioned, things will get more complicated, so I'm going through the examples here quickly. I would characterize this example as a variation of the first example where, again, the land ownership is bifurcated between legal and beneficial interest. So the legal ownership is by Heron, and Heron holds the legal ownership pursuant to a bearer trust agreement where the beneficial interest is held by Heron in their capacity as trustee of the alter ego trust. So in this case, we have an alter ego trust involved whose primary beneficiary and trustee is Heron. And the secondary beneficiaries are Eagle and Owl, which basically means that their interest is contingent on Heron's death here. For the purposes of this example, let's assume that both Eagle and Owl are the age of majority and won't speak to any age-related matters or issues. So Tiffany, once again, in this example, first of all, does it need to get reported on because the alter ego trust is exempt under the Act? And if so, who gets reported on? Because we have Heron here, who's the legal owner, who's also the beneficial interest holder through its capacity as a trustee, as well as the primary beneficiary. And lastly, I'm going to have you speak to whether or not Eagle and Owl need to get disclosed in terms of their interest holding. So over to you, Tiffany.
Thanks. So this is a question we've seen a lot, and I think the confusion comes from the fact that alter ego trusts, as you mentioned, are excluded from the definition of a relevant trust under Schedule 2. But in this case, we've said in the facts here that Heron is registered on title pursuant to a bare trust agreement. So Heron is acting as the trustee of a bare trust, which is a relevant trust under LOTA. Heron's not on title as the trustee of the alter ego trust. So that's why Heron is a reporting body in this situation and does need to provide a transparency report. So in this case, in terms of who you would capture on that report, Heron will need to be captured on the transparency report as a beneficial owner. One, because they have the ability to revoke the trust and receive the interest in land, and also because they're the primary beneficiary of the alter ego trust, so they're captured there as well. Eagle and Owl don't need to be disclosed on the report, and that's because their interests are contingent on Heron's death. So under the legislation, we don't capture interests that are contingent on death, so that's why we don't have to include them on the transparency report. In terms of who you would include as the settlor, again, as in the last example, because Heron is the settlor, but Heron is also the trustee, the definition of settlor under LOTA doesn't capture a settlor who is also a trustee of the relevant trust. So we don't need to include Heron on the transparency report as a trustee, but in this case, it's because we've already included all their information as the beneficial owner and the trustee.
Thanks, Tiffany. Now I'm going to turn it to Ruben, because Ruben, I'm sure you get a lot of emails about this, because Heron seems to be reporting on Heron holding the property for Heron here. So what have you seen and what tips you have for this structure?
Thanks, Marissa. I think the biggest thing that we've seen as far as inquiries and some confusion in the past was really the requirement whether or not Heron needs to file a transparency report, and the reason for the confusion was the fact that Heron was the registered owner, and we're dealing with an alter ego trust here who has that beneficial interest. So again, just reaffirming what Tiffany had just explained, notwithstanding the fact that Heron holds the interest in trust for an excluded trust, the alter ego trust, which is excluded under Schedule 2. Heron, as trustee, must still file a transparency report and then undertake that analysis and disclose the beneficiaries. In this case, Heron, which is me, who is the primary beneficiary as trustee. But that's really been the most of the questions probably in the first 6 months of LOTA filing was these type of scenarios, whether or not the trustee would have to file, even though it's holding that interest in trust for an alter ego trust.
Okay, so the lesson here is if you have a bare trust structure, even though there may be exempt entities or ownership involved, you still have to file. Okay, so let's move on to our next example and make it a little harder for Tiffany and Ruben. And this example involves two different discretionary trusts. So in this case, the real property is legally and beneficially owned by Company 1. Company 1 has two shareholders, Company A and Coho trustee in their capacity as trustee of Discretionary Trust 1. Now, looking at Company A is wholly owned by Sockeye trustee in their capacity as trustee of Discretionary Trust 2, and there are a number of beneficiaries under Discretionary Trust 2. Just a note here that we've distinguished between voting and total shares on these structures and on a number of the scenarios. In this particular analysis, it won't be a factor given the thresholds are met for both Company A to be analyzed as well as for Discretionary Trust 1 to be analyzed, but we'll speak to that on the further scenarios that we'll get to, and in particular the last scenario. Now, looking at company 1 again, as I mentioned, it's owned by company A, which we discuss, as well as coho trustee owning in his capacity as trustee of Discretionary Trust 1. Looking at Discretionary Trust 1, the beneficiaries of that are coho's spouse and children. Now, in terms of children, there are children that currently exist, and there are children that coho may have in the future. So this structure involves a couple of different questions I'd like to pose for Tiffany. First of all, Tiffany, who gets reported on? Because we have 2 discretionary trusts involved in different ways in this ownership structure. And which beneficiaries will be named in this report? And secondly, I'd like to hear your commentary on what happens if coho has future children, and how does that impact the transparency report and future obligations to file? Over to you.
Thank you. So as we get into some more complicated examples here, I just want to point out again that, as we mentioned before, none of these scenarios are meant to be considered legal advice. All of the analysis is always going to be highly dependent on the facts of the particular scenarios that you're looking at. So just to keep that in mind, that these are for discussion and to illustrate some examples of how you might work through some of these things. So in this case, we're dealing with a reporting body who's a relevant corporation. So we need to identify corporate interest holders under Section 3 of LOTA. So we'll do this piece by piece and start with Company A here. And first, we need to look to see if Company A owns a significant number of shares, because if Company A doesn't, then we don't need to keep going. But in this case, with 40%, Company A does hold a significant number of shares, so we do need to keep drilling through to determine who has indirect control of those shares. So in this case, 100% of the shares of Company A are owned by Sockeye as the trustee of the Discretionary Trust. As Prissa mentioned, you know, we've included the triangle here to show a trust, but that's really just to clarify that Sockeye isn't owning these shares in an individual capacity, but it's not the trust itself that owns the shares. So I just want to point that out, that we've done the diagram that way just to improve clarity. So if we look at the indirect control provisions, we need to include Sockeye as a corporate interest holder, because we capture the trustee of a relevant trust, always through indirect control. However, when we look at the beneficiaries, we don't need to capture any of the beneficiaries of Discretionary Trust 2 unless, under the indirect control provisions, any of those beneficiaries have the ability to direct the actions of the trustee. So assuming that the beneficiaries can't control the trustee, then we only need to capture Sockeye as the trustee on this side of the example. So next, looking at coho, this one's a bit different. We don't have that intermediary corporation here. We have coho as a trustee directly owning those shares in Company 1. Again, this is a significant number of shares, so we need to capture coho as the registered owner of a significant number of shares. And then we also need to capture, in this case, the beneficiaries as the beneficial owner of a significant number of shares. So that's Section 3(2)(a) sub II, I believe. So in this case, we'll get the spouse, we'll get all existing children who exist at the time the report is filed. As Ruben had mentioned earlier, if they're minors, it'll be automatically redacted from the publicly accessible information, but they do still need to be included. If in the future coho and spouse have more children, then that means that the transparency report no longer identifies the current interest holders. So Company 1 will have to file a new transparency report within 2 months of becoming aware of that. So essentially, anytime a new child is born who would be considered a beneficial owner, or sorry, a corporate interest holder under this example, then they need to be included on the transparency report.
So lesson is, if you have future children and you're caught in terms of your discretionary trust, when you get home from the hospital, don't forget about your LOTA filing requirements. Now, Ruben, I'm sure you have some observations on this structure, especially because it involves discretionary trusts. And I'm going to turn it to you to speak to this structure as well, and speak to how a transparency report may be completed, given that the beneficiaries of the coho trust is being disclosed.
Thank you, Prissa. For purposes of this scenario, for illustration, we've actually provided a sample transparency report in the subsequent slides, and that's based on the analysis that's been provided here to you. Now, a couple of things that come up quite often is around the disclosure of intermediaries. We get a lot of questions about, in this case, an example would be, where do we provide or disclose information in relation to company A? The answer is you wouldn't provide any information in the transparency report in relation to company A as the intermediary. LOTA only requires the disclosure about primary identification information about reporting bodies, about interest holders, and settlers in the case of trusts. And no other information is required. So that's just something to keep in mind. Secondly, as Tiffany had covered, we've had questions around disclosure of unborn children in the case of discretionary trusts. So at the time of preparing the transparency report, you wouldn't disclose any information about unborn children. At the time when the children are born, within 2 months of becoming aware, there's a requirement under Section 16 to file that new transparency report to disclose the new interest holders as well. And just a reminder here, the primary identification information about minors, again, are not disclosed. So you don't need to file a Section 40 application. And the mandatory omission of minors is set out in Section 31. My apologies, Section 39, Sub 1, Sub A. That is mandatory omission that's required by the administrator. One other thing I also wanted to point out is we get a lot of questions about the information required under Section 19A VII, and that is the information about the date on which the individual became or ceased to be an interest holder. And quite often the question is, what is the date? Is it the date that the relevant corporation or relevant trust or relevant partnership acquired the interest in land? Or is it the date on which the interest holder acquired their interest? Well, the answer is it is always the date on which the interest holder acquired those particular rights, interests, or abilities. In this case, those rights, interests, or abilities in respect of the relevant the relevant corporation here. So that date can certainly change depending on your filing. So in this case, let's say there's a newborn child, and when you have to respond to that question as to the date when the interest holder acquired those interests or rights, it would typically be the date the child was born, assuming there was a pre-existing owner, right? So the transparency report that we provided here gives you that example in the case of, let's say, the existing children. It is really the date when the children were born at the time. So it's not when the company acquired the interest in land. And that's sort of the main observations and items that I've seen, Parissa. So I'll just hand that back to you.
That's very helpful, Ruben. So to confirm, you can have a transparency report with individuals who have different dates in terms of when they became an interest holder, correct?
That's correct. And quite often, if you're filing a pre-existing transparency report for a reporting body with multiple interests in land, so multiple PIDs, it is entirely conceivable that you could have different dates for different interest holders. And as you know, there's only one section that you can enter the date for a particular interest holder. So as always, you have that discretion to add additional information in the free-form text box that's provided below if you wanted to specify the date on which certain interest holders acquired their interest in respect of those interests in land.
Yeah, absolutely. I can see that becoming a big question as folks do more transparency reports involving multiple properties and are doing their initial filing when they may involve different dates where someone became an interest holder in those properties. So that's very helpful. Thank you, Ruben. So moving on to our next example, and it's the first of our limited partnership examples. I know this is a hot topic, a debated topic among legal professionals. So we did not make it easy on Tiffany and Ruben on this one. So I'm going to take a minute here and let you absorb the complexity of this chart and go through it with you. In this example, we have a bifurcated ownership of the real property here. So the legal ownership is held by a bare trustee company pursuant to a bare trust agreement, where the beneficial interest is held for the benefit of limited partnership A. Now, the limited partnerships in this structure are shown in the triangle to distinguish between a company and a limited partnership. In this case, limited partnership A has 3 partners: the general partner company, LP company 1, and LP company 2. And I'm going to take a minute, go through each example here. So with respect to the general partner, as you can see on the chart, it has a very small interest, as a general partner would typically have. It is in turn owned by 2 corporations, Company A and Company B. And Company A and B are 100% owned by Fern and Salal, respectively. We then have LP Company 1, another partner in limited partnership A. And just a note here, these percentages were picked intentionally to show that even where there are small percentage holdings, they may be caught by LOTA and the disclosure requirements. So in this case, LP Company 1 only has a 5% interest as a unit holder in limited partnership A. LP1 is in turn owned by Rock Company, as well as Lupin Trustee in its capacity as trustee of Rock Trust. Looking at Rock Company, we made it a little complicated again here. It's owned by Company 1, 2, and 3 in its different percentages of 10, 30%, and 60%. But there's a shareholders agreement in place here where Company 1 effectively has control of Rock Company by dictating who the directors of Rock Company are. Looking at Rock Trust, the beneficiary of that, the sole beneficiary is Oak. Now moving on to LP2 Company. This entity is in turn owned by another limited partnership. Again, you have GP Company at a small percentage, and you then have 2 sets of interest unit holders. So LP Corp, which has 70% of the LP units, and then you have another about 30% minority shareholders of the LP of unit holders. So, Tiffany, everyone's been waiting for the ministry to clarify how a limited partnership structure like this would be reported on. And so I'll turn it to you to guide us through this and let us know who gets reported on.
Yeah, absolutely. So yeah, as we can see here, we're getting into the really intimidating looking structures now. So we're just going to work through this piece by piece. So in this case, we have a bare trustee company as the registered owner. So again, they're both a corporation, and in this case, a relevant corporation, and a trustee. So under Section 13 of LOTA, they need to file as the trustee of a relevant trust. So again, we're looking for beneficial owners under Section 2 of LOTA. Now, we've gotten a lot of questions about this sort of scenario where, an interest in land is held in trust for a partnership, because if you look at Section 2 of LOTA, we don't actually mention partnerships at all in that section that describes beneficial owners. And the reason for that is, and we've added some guidance on the ministry's website, is that we consider that the beneficial interest, a partnership essentially is not an entity that's capable of holding that legal or beneficial interest, so it needs to flow through to the partners themselves. So if a partner is an individual, then they're captured under Section 2A of LOTA, an individual who has a beneficial interest in the interest in land. And if the partner is a relevant corporation, then under Section 2C of LOTA, you would capture them as well, because we also capture an individual who's a corporate interest holder in a relevant corporation that has a beneficial interest in the interest in land. So in this case, because we have all three partners as corporations, we need to do a corporate interest holder analysis on each of them to determine who would be considered a beneficial owner. So we'll start with GP Company, and this one's fairly simple, and we need to capture both Fern and Salal as they both have indirect control of a significant number of shares. So we will capture both of them. They need to be included on the report. For LP Company 1, we would capture Lupine, again, in the capacity of a trustee. They'd be captured as the registered owner of a significant number of shares, and we would capture Oak as the beneficial owner of a significant number of shares. So we would get each of them on that first arm of LP1 Company. Looking over to the shares owned by Rockco, it starts to get a little bit more complicated here. As Prissa mentioned, there's a shareholders agreement between Company 1, Company 2, and Company 3. So even though Company 1 only has 10% of the shares of Rockco, they do actually control the appointment of directors of Rockco. So they do have indirect control of those shares. So that means that the control test would need to continue through Company 1, and we wouldn't need to drill any further into Company 2 and Company 3. In this case, we sort of ran out of space on the diagram here, so we haven't gone any further. For the sake of simplicity here, we'll assume that there's a sole shareholder who owns all of the shares of Company 1, and that individual would need to be included on the transparency report. So finally, we need to look at LP Company 2, or LP2 Company, sorry. And under the regulations, a relevant intermediary does include a relevant partnership. So we are looking at the indirect control provisions here to determine who we might capture under beneficial ownership. So under the regulations, a person controls a relevant partnership if they are a partner other than a limited partner. So that means that even though in this example, GP Company 1 only has a 0.01% interest in the partnership, they still have control within the meaning of the regulations, and so we would need to continue to drill through Company 1 to find any individuals who control that company. Again, we ran out of room, but for the sake of ease, we'll say that's a single individual who controls GP Company 1. Under the regulations, a person also controls a relevant partnership if they're a limited partner entitled to at least 25% of the profits. So in this case, if we look at LP Corp, we see that they have 70%, so we would capture them as well, and would need to continue to drill through that corporation to find any individuals who would need to be listed as a beneficial owner on the transparency report. And finally, we have multiple partners, minority partners. And even though we've included a single box here for those minority partners, I'll just point out that we have a number of different partners here, none of whom have a 25% interest and is entitled to 25% of the partnership profits. So we don't need to continue to drill through them. We don't have any control there. So essentially, you just need to look through GP Company 1 and LP Corp, but you wouldn't need to look through the minority partners at all.
Thanks, Tiffany. So I'll pause here and just confirm once and for all, even though LP1 company is only a 5% unit holder in limited partnership A, the analysis still needs to occur all the way through to determine interest holders that will be disclosed from that branch of the analysis.
Yeah, absolutely. And again, that's because we consider that limited partnership A, so the one that the beneficial interest isn't capable of holding that. So you need to flow through and look at all partners. So we don't have that same 25% threshold at that part of the diagram.
Okay, very, very helpful. Thank you. Now, Ruben, I'm sure after this discussion and analysis provided by Tiffany, there's going to be some folks who may think that they may have some errors or mistakes on transparency reports that they've already filed. Can you give us a bit of an overview and a tip on how to go about rectifying a filing that's already been made?
Thanks, Marissa. Yes, certainly, as Tiffany mentioned, we've received many inquiries, both to the LOTA administrator and to the province as well, in regards to how to apply this type of scenario, how to file a transparency report, and consequently, which sections of LOTA and its regulation apply and how do you apply them. There's been a lot of questions, particularly for pre-existing scenarios. And I'm really pleased to see Tiffany provide the in-depth explanation and the analysis here. So if a transparency report was previously filed and the basis of the analysis differs from what has been shared here today, then what I strongly urge reporting bodies to do is to file a brand new transparency report as required under Section 16 of LOTA. That's really, if you've done an analysis that differs here and leads you to a different conclusion as to who should be disclosed, then with your new analysis, you reach a different conclusion with a new set of, interest holders that are beneficiaries are supposed to be disclosed. File that new transparency report under Section 16 as soon as possible. Really, the statute requires the reporting body to file that within 2 months of becoming aware of that change. So that is what I would strongly advise.
Thanks, Ruben. Now, Tiffany, I'm sure you're aware the Act has very severe penalties for misinformation or misfilings. Can you speak to how the ministry may treat a filing error or a filing mistake that is then potentially corrected, especially in a context like this where there is quite a complicated structure analysis involved?
Yeah, absolutely. So I'll preface this by saying I myself am not the enforcement officer, so I can't really be, the definitive answer on what the enforcement officer might do. But I will just point out that under the legislation, there's certain things that the enforcement officer always needs to consider in determining whether or not a penalty would apply or what kind of penalty would apply. And so that includes things like whether or not the violation was deliberate, whether it was, the reporting body had repeated violations, if they had derived any economic benefit from filing incorrect information, or if they had made any attempt to correct the information. So again, while I'm not the enforcement officer, I expect that they likely wouldn't consider it, a willful deception if efforts had been made to correct a transparency report after recognizing an error. The enforcement officer also has an education role, and they might consider, education and compliance measures instead of penalties where appropriate, especially in cases where, there had just been an analysis of or a complex structure that later the reporting body determined the initial analysis was incorrect.
Thanks, Tiffany. That's very helpful. Now, just to pause here, because I know a lot of legal professionals appreciate this. This is a complicated structure, and we are pausing to look at the org chart for the purposes of this this session. But the materials do go in depth and provide further information. So if you've been scrambling notes fast and furious, don't worry that this information is available and is posted on the Land Transparency website. But I do think it does highlight the fact that LOTA is not simple. The application of LOTA is not simple. And when there is complicated ownership structures at play, there is an in-depth analysis that is required. So as Tiffany and Ruben have been mentioning, make sure you get legal advice where you require, and that you file trying to comply with the Act and the provisions, and make any updated filings that may be needed if there was an error. Okay, so I said I wasn't going to make it easy on Ruben and Tiffany, so let's look at our last structure. I would have made it more complicated, but I don't think the screen could have handled that right there. So there's a couple of different concepts at play in this structure, and we'll go through it one by one. Again, it involves another limited partnership but in this case, the real property is the title on it. The legal title is owned by the general partner of the partnership. And the limited partner, in addition to the general partner, has two other partners, LP Company 2 and LP Company 1. So once again, just to pause here, these percentages on this chart, including the split between voting and total shareholdings, has been intentionally picked, and it's been done so to illustrate the complexities around the analysis. And we'll hear from Tiffany on that more in a minute. Looking in this structure, let's start with the simple one, the general partner. The general partner is 100% owned by Birch. Now, behind Birch, there is Fur, who has a direct and significant influence over Birch. An elusive concept, but I like to think of my toddler, who exerts direct and significant influence on me personally all the time. Looking at the two LP companies, let's look at LP 1 company, who owns 96.99% of the units in the limited partnership. It is in turn owned by company A, B, and C. Now, looking at company C, it has 10% of the voting shareholdings, but only 5% of the total shares. It is in turn owned by Larch and Aspen, who again have different percentages, varying percentages in terms of voting and total shares. Looking at company B, it is owned by Hemlock and Spruce, who are spouses. And Hemlock only has a 5% voting and total interest, and Spruce has 95% of the voting and total interest in company B. On company A, we have Pine and Cedar, who jointly together 50-50 own the voting and total shares here, so equal in terms of their ownership into company A. Moving over to LP2 company, this entity only has a 3% interest of the units of the limited partnership, so a small percentage, and again, intentionally picked here. It is in turn owned by company D and E. Looking at company E, it is owned by Yew, Juniper, and Cypress. Now, Juniper and Cypress only have small percentages of voting and total shares, but they are associates of one another in terms of how LOTA treats the concept of associates. Looking at company D, you have Alder and Maple, who own company D, again, in varying voting and total shares here. So, Tiffany, there's a lot to dissect here. And I'll let you guide us through it, but with each one of these LP partners, we try to have a bit of an interesting twist to them, including direct and significant influence, spouses involved, and associates involved. And we did make the shareholding structures quite complicated, so I don't know who the tax advisor was, but didn't make it easy for us to analyze this one. So turning to you, Tiffany, can you guide us through this analysis of ultimately who gets reported on in the transparency report?
Absolutely. So in this example, this is the first one we've seen where the reporting body who's filing is filing as the partner in a relevant partnership. So we're looking at section 4 of LOTA to determine who we need to capture here. So as we see here, the general partner is registered on title as, you know, the registered owner for the partnership, but it is partnership property, so they are filing as a partner in a relevant partnership. And I'll point out here again that unlike the indirect control example that we went through, under section 4 of LOTA, all partners of a relevant partnership are generally captured, so we don't have that same 25% interest threshold for limited partners that we looked at when we were dealing with indirect control. And so the reason for that, again, is because for indirect control, you're trying to determine what individuals have indirect control of a corporation shares, whereas here we're talking about a more direct interest in land. So again, the legislation assumes that all partners are partnership interest holders. So in this case, because all of the partners are corporations, that means we need to do a corporate interest holder analysis, because any individual who is a corporate interest holder of one of the corporate partners would be considered a partnership interest holder for the purpose of the report. So again, we'll go through one by one, starting at the leftmost one here, LP Company 1. So for Company A, again, as Prissa mentioned, this is an interesting one because although Company A only has 5% of the total issued shares, they still actually have a significant number of shares, and that's because they have 20% of the voting rights. So a lot of times it can be easy to just focus on the 10% threshold for total issued shares. That's the one that we generally discuss. But in this case, even though there's only 5% of the issued shares, that 20% of the voting rights means that we need to keep going through Company A. But in this case, neither pine nor cedar meet the control test, and that's because, again, it's a 50-50. Neither of them has a majority. And so assuming there's no shareholder agreement or some sort of associates relationship or anything like that, then neither of those individuals meet the control test, so we don't need to capture either of them. For Company B, if we look at that, again, Company B has a significant number of shares in LP1 companies, so we need to keep going. And Spruce, based on their share ownership, does have indirect control of a significant number of shares of Company B. So they definitely need to be captured on the report. But Hemlock also needs to be included on the transparency report as Spruce's spouse, because they would then be considered associates under the legislation. So we need to capture both Hemlock and Spruce on the transparency report. So looking at Company C, again, that's similar to Company A, where you have that kind of odd mix where there's only 5% of the total shares, but 10% of the voting. So 10% or more of the voting rights is captured. So we do need to keep going here. And in this case, Larch would be the one who would be considered to have control of Company C and indirect control of those shares in LP Company 1. So Larch would be included on the transparency report, but not Aspen, because they don't meet the definition of control under the regulations. So moving to GP partner company, this one is fairly clear, obviously, that Birch needs to be included on there because Birch owns 100% of the shares in the general partner co. But we also need to capture for, again, as Prissa mentioned, we have that direct and significant influence. And that, I mean, it could be a number of situations that would create that scenario, but just a point that even though FIR doesn't own any shares in general partner, they still need to be captured on the transparency report. So finally, we can look at LP Company 2. And so we'll start with Company D. So Company D also owns a significant number of shares in LP Company 2, so we need to keep drilling here. And in this situation, we have Alder, who would be considered to have indirect control and would need to be listed on the transparency report as a partnership interest holder, but Maple wouldn't, because again, Maple doesn't meet that control test. And finally, Company E, we do need to look through them because again, 40% of the voting and 10% of the total, so they meet both tests. We need to keep going here. And so in this case, we would capture U as having indirect control of a significant number of shares and capture them on the transparency report. For Juniper and Cypress, again, because we have that associates rule, we need to add their interests together to determine if they meet the threshold. But in this case, even adding them together, there's not enough of an interest to create indirect control. So we don't need to capture Juniper or Cypress on the report. So ultimately, in the end, we're going to have GP partner as the partner in a relevant partnership. We'll file a report that identifies Hemlock, Spruce, Larch, Birch, Fir, Alder, and Yew.
Thanks, Tiffany. I'm having a little mini heart attack thinking of that email to the client here. In terms of gathering of the information involved. And, you know, just a note here that sometimes we just get an org chart and someone says, tell me who needs to get disclosed. And it's not as simple as that. You need to keep asking questions and figure out under the Act whether or not there are relationships that may be caught or that may require analysis that is slightly different than just looking at percentages of ownerships of shares. So Ruben, we got quite a few folks here to disclose. I'm sure you've had some emails and questions when
when folks are looking at their chart and figuring out how to even find that information to try and put it in a transparency report. Any thoughts?
Yeah, thanks, Parissa. So yeah, in these type of complex scenarios, quite often a question from the legal community is, we were dealing with a large number of interest holders that may have to be disclosed in a transparency report. And in some cases, some of these individuals are located globally. We can't even reach them. We're unable to collect all of the primary identification information about them, or the information as required under Section 19 about interest holders. What do we do? So really under LOTA, the reporting body has an obligation to take the necessary steps to collect the information that is required. Now, in the event that the reporting body has taken all the necessary steps and still unable to collect information, let's say information about the last known address of an interest holder, or the individual's ITN or SIN number, then under Section 21 sub 4, LOTA gives the reporting body the ability to actually just basically state the steps that provide a summary of steps that the reporting body had taken in respect of their interest holder to collect that information, and then declare that they were not able to confirm or collect all the necessary information. So there is that requirement to confirm that those steps were done. If not, you provide the statement. Now, subsequently, if the reporting body is able to obtain that information, then the reporting body would file a new transparency report under Section 17 to correct or complete a previously filed transparency report. The one thing I'll just say is, just in this type of a scenario where you have a general partner who's holding that interest in land, which is partnership property, as part of our limited partnership, then a lot of the question has also been, how do I file that report? Under Section 13 sub 3, you file that as a partner for relevant partnership.
Thanks, Ruben. So we did it. We got the tough partnership questions out of both Ruben and Tiffany. We looked at examples where the partnership had a nominee on title and a general partner on title, which are two typical examples that we typically see in holding structures. Now, I'm sure after this presentation, there's going to be lots of questions or further inquiries about LOTA, about the analysis involved, about the role of the ministry and enforcement and clarifications. Don't call me. So, Tiffany, they should call you, right?
No. Don't call me directly. That's not the best way to go about things. But we do have some information here about where you can go for further information. So here we just have a bit of a screen cap of the LOTA Government of BC website. So we have some information about the enforcement officer's role, as well as some interpretive guidance. So you can see here some of the issues that we've currently provided guidance on, and we are continuing to update that as we see more questions from people who are filing transparency report, areas where there may be, where people are having questions about how the legislation applies. So I would recommend that you maybe kind of bookmark that page, go back to it. If you ever have a question, you can check and see if there's been some guidance provided on that. So that's the first place you could look. And then on the next slide here, we have our enforcement officer email, lota@gov.bc.ca. So if you have some, really technical questions about how to apply the legislation, some interpretive questions, then you can direct it to that email. Again, when Ruben went through his presentation, he provided the LTSA email for questions about how to file a transparency report, technical questions about, my LTSA, or how to sort of actually go about submitting the report. But if your question is about how the legislation applies to the reporting body that you're looking at, or just how to interpret the legislation, then those questions should be brought to the email that you see here. rather than to the LTSA.
Thanks, Tiffany. And I know we scheduled an entire hour and a half, just given the complexity of the content, but we did want to be mindful of time and try and finish a little ahead of time to give some time back to the audience here. But before we go, just a reminder of the important filing deadline and to file as soon as possible, and to contact Tiffany and Ruben pursuant to the links that were provided, and not personally and directly, because they won't be able to answer your questions. Again, these slides were meant to be examples and not provide legal advice or legal analysis. So please consult with a legal professional in trying to undertake a LOTA analysis with respect to ownership structures and filing requirements. And I'm sure, you know, further clarifications and issues may arise, so we'll keep at it. But thanks again, Ruben, and thank you, Tiffany, for the time and effort that you have put together to put this presentation material and the analysis involved. Now, this material will be available via a link, downloadable link on the Transparency website. So again, if you didn't get a chance to download the presentation material before, it will be available, as well as a recording of this session will be available. So no need to try and go back on your notes to try and figure out what you said exactly. And thank you for the participants who joined us. Last I heard, there was about 1,000 participants signed up. So thank you for taking the time and joining us here for this presentation. I'm sure you were all anxiously awaiting some of the commentary here. Thanks, everyone. Bye.